It's unlawful to treat suspects as criminals simply because they are being regarded as suspects in a case. This is clearly against the law as provided for in Section 35 of the 1999 Constitution. Although it's believed that the violation of these rights have become so rampant in Nigeria in recent times, we'll be looking at various ways this happens on the program today. Welcome to Law Weekly on Channels Television. I'm Victoria Idowu. When a suspect is regarded as having a right, is acknowledged to be entitled to something to which he has just claimed to under the law. Recently, the former Chief Security Officer of the past President Goodluck Jonathan, Mr. Gordon Obua, was detained by the Department of Security Service. His lawyer laid several accusations against the DSS, some of which Mr. Gordon Obua refuted. Well, whether it be true or not, we would be using this as a case study as we discuss the right of an accused person. But before then, let's take some court stories. And please be informed that what you're about to watch contains flash images.
Most of the existing laws in Nigeria are outdated and do not fit in with the realities of time. This is according to the Speaker of the House of Representatives, Honorable Yakubu Dogara, who has inaugurated a 22-man committee on legal reforms for various sectors of the economy.
Ladies and gentlemen,
the committee, which has a 60-day time frame, is expected to review and suggest new laws and reforms that will, amongst other goals, help the anti-corruption struggle, infrastructure renewal, and optimal utilization of the nation's petroleum resources.
The major reason that informed the setting up of this committee is the urgent need to review the various laws that thought as statute books, some of which have become obsolete, anachronistic, outdated, and spent. Your committee is being inaugurated today to assist us in cleaning up our statute books and bringing all our laws up to date in order to meet the social, political, and developmental needs of our country. Apart from reviewing existing laws, law reform involves introduction of new laws where necessary. Laws that aid the anti-corruption struggle, infrastructure renewal, efficient and optimal utilization of our petroleum resources, solid minerals, education and social services, agriculture, diversification of our economy, and massive employment of our teeming youthful population.
Fresh from the public holiday, the Akwa Ibom State Tribunal settled down to business. At the sitting, the All Progressives Congress complained about the difficulty in carrying out the inspection of the election materials. The party says, in spite of the order of the court, the Independent National Electoral Commission made it impossible for the party officials to continue the inspection and therefore demanded for more time. However, the governor of Akwa Ibom State, the People's Democratic Party, and the Independent National Electoral Commission opposed the application on the ground that the facts were not rightly stated by the All Progressives Congress and its candidate. The party, through its lawyer, Tayo Oyetibo, urged the court to refuse the application, except the petitioners come only on the strength that the inspection could not be carried out during the public holiday.
It's common ground. It was common ground that the people were not available during the holidays. And so the court had no difficulty in allowing us to have the benefit of those days that were lost.
If you are indulged because you were not diligent in doing what you ought to do, then of course it would look as if the court should not really give you that kind of discretion. But in this instance, we all agreed the court has the powers, and if the court exercises those powers in their favor, and given the fact that we don't lose anything strictly speaking, we support what the court says.
We took the view that if you come to court to ask for extension of time to take a step, you should be forthright in what you present to the court. And that's exactly what the point we were making. At the end, we eventually considered to them that they can have more time. But it's always good to say it as it is. And that's what exactly we are trying to put across to the court.
Earlier at the proceedings, the All Progressives Congress presented some of its witnesses who alleged that There were hijacking of election materials in some cases before the election commenced, and in others after the voting process by top members of the ruling party in the state, rendering the process inconclusive. Out of its over 800 witnesses, the party has only been able to present 16. The tribunal has given the All Progressives Congress an additional 4 days to inspect the election materials. The Governorship Election Petition Tribunal, sitting in Owerri, the Imo State capital, today dismissed the petition filed by the PDP governorship candidate in Imo State, Honorable Emeka Ihedioha, challenging the victory of Governor Rochas Okorocha in the last governorship election. Delivering the judgments, the chairman of the tribunal, Justice David Wiom, dismissed the case on the ground that the plaintiffs abandoned their petition, having failed to pay for the pre-hearing notice within 7 days stipulated in paragraph 18(1) of the rule guiding election petition proceeding. Justice Williams stated the validity of the process starts from when the pre-hearing notice payment is and not when it was applied, which in turn means the petitioner paid out of time but applied within time. On the 13th of June 2015, a federal high court granted the former head of service interim bail based on self-recognition and undertaken by his counsel that he will be present in court along with his co-accused. He, however, ordered that they return to argue their bail application. Justice Gabriel Kolawole, while delivering ruling on the bail application, said he considered the status of the accused person as a former head of service of the Federation before granting him bail on self-recognition. The second accused person, Mr. Osarinkwe Afe, was however admitted to bail in the sum of 50 million naira and 2 sureties in like sum. One of the sureties must be a serving or retired civil servant or below level 16. The second surety must be an entrepreneur who owns a landed property worth 75 million naira, who should provide 3 years tax clearance certificate. Both sureties must provide 2 passport photographs and swear to an affidavit of means. Justice Kolawole ordered that should the second accused person not meet his bail condition by the 27th of July, he should be rearrested and remanded in prison custody in Abuja. Meanwhile, both accused persons shall continue to enjoy their interim bail granted to them on the 13th of July, pending when they perfect their bail conditions.